Hey folks, welcome back to the channel. Today's case is proof that small claims court doesn't mean small drama. At the center of this chaos is a loan of $1,870. The plaintiff claimed the defendant failed to repay the agreed amount, while the defendant argued unrelated grievances and claimed partial repayment without proof. The real fireworks come at the very end, with a verbal outburst so over the top it almost landed the defendant in more trouble than the debt itself. Buckle up, because this case is a roller coaster you don't want to miss.
All right, thank you.
All right. So this is file 2402771SC, a small claims case, Brower versus Bursma. We're here in small claims. What that means is nobody is represented by an attorney. We're trying to resolve this here in front of me. It also means that no one's asking for something like a jury trial, but for this to be decided right here now in front of me. So if the parties are ready and willing to proceed in front of me, Mr. Bursma, you just put yourself on mute so that I would not be able to hear your responses. Please take yourself off mute.
Well, thank you.
Mr. Bursma, you have muted yourself. There you go.
There you go.
All right. So if parties are ready and willing to proceed here in small claims, I'm going to swear you in. Ms. Brower, you have your camera off. I would need to see you so I can see you raising your right hand. Same way Mr. Bursma is going to raise his right hand.
Hold on.
It doesn't matter. Mr. Bursma didn't listen to me anyway.
Mike.
Well, you might as well wait. Brower hasn't figured out how to turn her camera on.
Yes. Okay.
All right, there we go. Everybody raise their right hand. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yeah, I do.
All right. So I do have some information here. It seems like there was an agreement that Ms. Brower was going to put up some money for Mr. Bursma. Mr. Bursma was supposed to pay that money back, and we're here because that money hasn't been paid back, and that's why you're suing. My question is, Brandon Bartholomew is a public defender in Ottawa County. Why are you paying a public defender?
I'm not paying nobody.
Yeah, I know. I'm asking Ms. Brower. Ms. Brower, public defenders are attorneys paid for at taxpayer expense. You don't have to pay them.
Okay, well, that was a court case for him, and that is, I have all his court papers from the day we went to court.
Okay, ma'am, answer my question. Brandon Bartholomew, you have listed as a public defender. Public defenders, you don't have to pay for. They're attorneys at taxpayer expense. So why are we paying a public defender attorney?
I didn't pay him. I gave Mr. Bursma the money to pay his defendant or his case, so to keep him in the jail.
Okay. Mr. Bursma, do you agree that there is, in fact, money here that you owe back to Ms. Brower, and it's more about how and when you can pay that, or are you contesting that you owe money?
I don't owe her any money.
Okay. Did she give you $1,200 so that you could pay for a court case?
Yes, she did, but she's got $15,000 of mine, and I don't owe her any money.
Okay. And there was an agreement on top of that $1,200 that if you didn't pay back $100 every week for 12 weeks, there would be a late payment attached as well, correct?
Yeah.
Correct.
All right. So that's $1,800. That's the damages. Ma'am, that $55, I understand what you're saying that is. That's money you paid out of pocket. You paid to have a filing fee, and you paid to have him served. You actually paid $70 to do all that.
Right.
You are entitled to that money as well, but we call that costs, not damages. So I have your actual $1,800 damages and $70 cost for a total of $1,870. All right. Sir, I'm going to give you an opportunity to explain to me why you wouldn't owe her that money. You guys had a promissory note signed.
Yes, I understand we had a promissory note signed, but since then, she's sitting on $15,000 of mine, and I don't owe her that money.
That is neither here nor there, sir. This is
Okay.
a contract you signed. You have to honor that contract. Now, maybe you need to sue her for something. I don't know what you're talking about $15,000. But did you pay any of this promissory note back?
Yes, some of it.
Okay. Miss Brower, did you receive any of this $1,800?
I have not, because I would have record of that, and he knows I'm a good record keeper, so.
Yeah. Mr. Bursma, how did you pay?
I gave her cash.
You got a receipt for that, a written note from her?
I would have to do some checking.
Okay, well, today's the day you're in court, right?
Okay. Well,
So
I don't. I
checking
mean,
after today isn't really going to do you much good, is it?
nope.
All right. So you don't have any receipts or proof that you paid her any cash.
Not on me. Nope, sir.
And Miss Brower, you're testifying he did not actually give you any cash towards this amount.
Correct.
All right. So I'm going to order $1,800 in damages, $70 in costs. It's a final, a total amount $1,870. I will send that judgment out to both parties. Both parties have a right to appeal that. Ms. Brower, I'm not sure why you would. It seems you're getting everything you want. For Mr. Bursma, if you disagree with my finding here today, you do have a right to say, I don't agree with what just happened there. I want to go to general civil in front of the district court judges. To do that, you must ask for that within 7 days of today's date, and you must do that by written motion. You cannot ask for it orally. Do you understand your rights on appeal?
Yep.
All right. Then we're all set for what we need to do here today. I'm going to go ahead and release parties. Thank you.
Thank you.
Bitch.
Ooh.
Fucking Kimber, fucking bitch.
Sir, do you want to be found in contempt in court and then you can go to jail for a little bit on top of paying the money?
No, sir.
All right. Thank you.
Sir, I have a protection order against him for an assault.
Okay. You're all set, ma'am. I'm going to go ahead and release you.
All right, thank you.
Sometimes it's not about the amount of money, but the amount of drama people are willing to bring to court, and the defendant didn't disappoint. It's also a reminder that courtroom etiquette isn't optional unless you enjoy teetering on the edge of contempt. What do you think? Should the judge have dropped the hammer, or was the warning the right call? Let me know your thoughts in the comments, and don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.